what criticism that provision has elicited? Or in your view, whether it is a salutary provision?
I think, in my view, my Lord, that provision to some extent may not be fair, in line of the fact that sometimes the first wife would have been the one who was a major contributor to the acquisition of the property that forms part of the estate of the deceased person, in view of the fact that as Africans, most properties are registered. They are registered under the man, even if they are acquired by the wife.
Have you had of any occasion to read any authorities on that issue?
Not of late, but I think I have, but I cannot remember. I cannot remember right now. But the fact is that where previously the law favored, the customary law favored the subdivision of the estate of a polygamous man equally. It favored that person's equally. At least the provisions of the the Law of Succession Act have tried to assist that.
Okay.
Yes.
Thank you.
Thank you, my Lord.
Counsel, I have a few questions for you. I've looked at your sample writings that you presented.
Yes, my Lord.
Including the opinion that you gave, the opinion that you gave to your client, the KTDA.
Yes, my Lord.
I like the way you structured your opinion.
Yes, my Lord.
And that an opinion is almost akin to the way you structure a judgment. Yes. But for you, for the purposes of my question, now you'll not be addressing your clients or the the court, because now you normally do your pleadings, you do your opinions to your client, and then your pleadings to court, and you also argue.
Yes,
in your submission, using your submissions. But this time, the audience is different. It is the parties, and finally, the judgment will speak for you
yes,
in terms
Lord.
of the public reading. So how do you intend to outline and write your judgments? I'm sure you are preparing in case you are appointed.
Yes, my Lord. Thank you. In preparation of the judgment, I would, upon completion of hearing and upon receiving submissions, I would sit down, read through the evidence once more and the pleadings,
Yes.
sit down, do an introductory part, set out the facts as the evidence that has been given by either parties, set out the key issues for determination, then analyze those issues for determination, then eventually I give or render my decision based on the analysis that I have made and the conclusions that I have reached.
Okay. How do you carry out your research? Because for me, writing and submissions is almost similar. You apply the same tools, and you use research methodology and so on. But how do you normally carry yours, and how do you intend to, let's say, employment dispute?
My Lord.
How do you intend to do your research?
Thank you, my Lord. I think what I left out earlier on was that I would also consider case law in rendering my judgment. I would look at past authorities. So in order for me to carry out my research, I think research these days is made easy because we have the ability to conduct research online the Kenya law reports and other law reports from other jurisdictions, which in my current station I do not really have I do not have access to, but I believe that when I get to the judiciary, I hope that I'll have access to those reading materials from other jurisdictions. But I also look through, I sit down, go through the search engine, and based on the relevance of the matter that is before me, I do my research. Sometimes I also talk to the pupils that are under me. I explain to them that the issue before me, and I ask them to research on my behalf, and I look at the research, and when they make the reports to me, I confirm whether the research is in line with the issues that I was delving into.
Okay. Finally, I can see that in some of your submissions, quite a number of them are fairly lengthy. I don't think sometimes, due to the amount of work that judges do, or judicial officers for that matter, time is not, you don't have the luxury of time. How do you, and the issue of being concise is very important, but clear and to the point.
Yes, my lord.
Yes.
I think that is a default. I can be short and clear and concise when called upon. And in fact, in certain cases, the judicial officers or the judges limit the number of pages that a submission would be. And in particular, in the Court of Appeal, I am aware that there is a limit to the number of pages that we can submit, and therefore, when called upon, I am able to do a concise and short summary of the matters before me.
Okay. Thank you very much. I wish you all the best.
Thank you, my lord.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon, Commissioner.
Okay, remember in my earlier years, we used to work together on FIDA issues. It's not only Vice Chair, it is known to you. So the initial question I needed to ask, as you've already responded when the Chief Justice asked the question. So Socrates says elements of a good judge are to hear courteously, to answer wisely, to consider soberly, and to decide impartially. On the issue of courtesy and consider soberly, there has been concerns, and I think now with social media, there's been concerns that certain judges or judicial officers, the language they use is not courteous. Have you experienced that, or have you seen that, and what is your thought about the issue of non-courteous language?
Thank you, Commissioner. In my 32 years of practice, of course, I have come across several judicial officers and judges, some of whom have been less than courteous in their dealings with us. But I find that it helps when I understand the temperaments of the judge. Sometimes some of those judges are undergoing very serious personal issues that we may not know. And therefore, I try as much as possible to be courteous with them also. I do not return the fire with fire, so to say. I address them respectfully. I am humble, naturally I'm humble, so I address them humbly. And a lot of times I find it helps. We had a judge in Kericho at one point where people were not understanding how he would get along with me. But he would get along with me because I gave him due respect. And I think this springs from my jurisprudence, that I need to understand the temperament of a judge, and I need to understand their leanings in order to know how to deal with them. Nonetheless, as a judicial officer or a judge, one should try as much as possible to be sober and to be respectful, because that would be upholding and promoting our principles and values as espoused in the Constitution.
Okay, so you have mentioned that at times judges or magistrates are handling personal issues, and this then becomes visible when they engage with litigants.
Yes.
So how would you ensure that, in as much as you've said that you're a courteous person, which I know that as a fact, how would you ensure that personal issues does not affect your work as a judge?
Thank you, Commissioner. For me, over time, I have developed my character. I've worked on my character to the extent that I am able to disconnect my personal feelings from the work that I do. And it was born of the fact that some of the employees that I've had in the past have let personal issues spill over. For example, there was a time I had an associate to whom I would send clients, and they would come back and tell me, no, I do not want that advocate, and I would ask them why. So one day I went to sit down, and I found out, and the advocate broke down, and I found out that she was going through so much. And it is born of that that I decided to work on myself, so that I'm always conscious as I deal with members of the public that I need to ensure that I am courteous, I am respectful at all times. Even as I deal with my clientele, there are those who will come and accuse you falsely, sometimes of delaying their matters, sometimes of colluding with the other side. But I find that I'm able to maintain my cool, and I'm able to handle them in a manner that will resolve the issue amicably.
Okay, thank you. Let me just try and inform you of how the life of a High Court judge, I'm not one, but having sat at the commission, I'm able to understand how their life is. So averagely, a judge is expected to hear 1,200 cases per year. They're expected to write judgments within 60 days. Judges carry their files in meetings, at home. They do not have a social life. You have indicated rightly that a station like Kericho, the infrastructure is not sound. So you'd find yourself in a station with not very good infrastructure. Are you ready for this?
Yes, I am, Commissioner.
Okay.
As I said, I have given much thought to it, and I am ready.
Okay.
Thank you, Commissioner.
Thank you. Lastly, I see you are also a director at a hospital.
Yes.
So once appointed, how would you ensure that there is no conflict between your role as a judge and anything that can come out of that hospital, any legal issue?
Thank you, Commissioner. I've already made arrangements, and if appointed, I will hand over the helm of the hospital to somebody else in the family. I will remove myself from anything that is likely to conflict with my duties as a judge.
Okay, thank you. Well, that's fair enough. Thank you, Chair.
Thank you, Commissioner.
Thank you. All the best.
Thank you, Chair, and welcome again, Honorable Alice.
Thank you, Commissioner.
Now, when we were preparing for this exercise, we engaged the stakeholders, and they told us they would want a judge who understands the complexities of the judicial system, including the challenging environment and power dynamics. Do you agree with this statement, and why do you think it is important?
Thank you, Commissioner. The complexities of the judicial system and the dynamics thereof are important to any person who intends to work in the judicial system, because one needs to be ready to adapt to change. One needs to be ready to adhere to the work ethics and the integrity of the institution, one needs to be ready to embrace new developments, both in the law and in the society, because we have a dynamic society where their values keep changing, and unless one is ready to adopt to those, then that person is not able to fit into the judicial system, Commissioner. I hope I have answered. I hope I got it right.
Okay. Fair enough. Now, explain how the role of the judge has changed from that of a traditional judge, as we have always known.
Thank you, Commissioner. 32 years ago, when we began, the role of a judge was simply that of an arbiter. The judge would sit down, hear matters, render decisions, and go home. Currently, the judge is very much supposed to be engaged with the society in line with the new constitution. One has to play the role of a facilitator, where we need to embrace alternative dispute resolution. One has to be alive to the national values of respect and dignity, and therefore one has to ensure that in dealing with the parties, the witnesses, accused persons, and other stakeholders, the judge demonstrates ethos for them, demonstrates respect for them. We need to make sure that we are aware of the need to treat all persons in society equally, and that includes the accused persons, that includes the old people in society, and the other vulnerable communities and the marginalized communities. And so the role of a judge basically has changed to that of a person who is not so far away from the people. A judge now needs to be closer to the people without necessarily compromising on the office and the integrity of the judge.
Thank you. I hand you back to the chair.
Very much.
Thank you.
Thank you, Chair. Good afternoon once again.
Good afternoon, Commissioner.
Maybe you could share with us why you feel it is important to measure performance in the work environment.
Thank you, Commissioner. Performance is key in every work environment. We need to measure performance qualitatively and also quantitatively. And it is important for that to be done in order to ensure that every officer or every staff member in an institution is doing what they are supposed to be doing. And so in the judicial context, performance needs to be measured in order to ensure that we eradicate backlog, that every judicial officer or judge puts in their best.
Before we get to that, I just wanted to know the importance.
Okay.
So now the next question is, do you have a framework in your law firm? You've indicated that you have your own law firm.
Yes.
Earlier you even mentioned that it's not a very big, in terms of the staff you have.
Yes, Commissioner.
But do you have a framework for measuring performance for your staff members, maybe even for yourself?
Yes, Commissioner. Thank you, Commissioner. In my law firm, I have put in place some standard operating procedures that enable us, first of all, to ensure that when we receive work from a client, that it is done to the standards that are required. I have assigned duties to my 2 associates. Each one of them has a docket which they head. I have assigned duties to the paralegal staff that I have, and every quarter, on a quarterly basis, we sit down, we evaluate the work that has been done, the output that has been done, and even as we do returns to the clients, especially the corporate clients, because they need frequent returns, we are able to tell whether or not we have done our work properly.
And how would you assess your performance?
We assess our performance by the turnaround time in the matters that we are handling. We also assess it by the success in the matters that we are handling. We also assess it by the failures, because we sit down and do an analysis, a SWOT analysis,
What went
in
wrong?
order to know what went wrong, where we would have done right. So we sit and do that. We tend to sit as a team, especially when we have complex matters. We sit as a team to do pre-trials together and to agree on a way forward with a matter. And so it is easy for us to assess our performance. We also have a bring-up system, which I am able to look through and tell whether or not an associate has done the work that was required of them at the particular time.
Okay, that's good. Now, let's now go back to judicial work in case management. That is provided for under Order 11 of the CPR, the Civil Procedure Rules.
Yes.
What exactly is the objective when you go through that process? And what orders do you envisage yourself giving as a judge? 3 orders.
The objectives in Order 11 are, first of all, to enable the parties to prepare for hearing and to ensure that all documentations and all evidence is in place prior to the hearing, so that we avoid unnecessary adjournments. It also assists in discovery, so that parties do not spring evidence on the other ones. And as a judge, I would see myself giving directions.
Do we only always prepare for hearing when we're doing case management conference?
Not necessarily.
Yes.
So one of the orders we would see, the first direction I would make is to ask the parties whether they can explore ADR as an alternative.
Yes.
And if possible, I would refer the matters to ADR before considering hearing.
And of course, stay the matter. So that is one of the orders you would give. The
That's
other
one
one?
of the orders I would give. One of the orders, the other orders I would give is, of course, where a party has not complied, I would give an order that the party complies.
No, the final stage, at the final stage of pre-trial. So we have finished, we have complied, everything has been done.
Yes.
So the kind of orders you'll be giving at that point, you've given me one,
Okay.
where you stay your proceedings and direct them to go for ADR.
ADR.
Yes, another
So
one?
the other order is for the matter to proceed, either by way of submissions or orally,
Yes, that is
Yes.
now setting it for hearing.
setting it for hearing.
The third one?
I think I may not be remembering that.
Is it possible to settle at that stage, to settle all the issues at that stage?
Yes, we would see whether it is possible to explore settlement out of court.
Yes.
Yes.
Okay.
Thank you, Your Honor.
My last question. There's a phrase we have, the multi-door approach to justice. A colleague of mine already alluded to it earlier when they were engaging you, but I just want to hear from you. How do you think as a judge you can promote the multi-door approach to justice?
I think one of the key issues in promoting multi-door approach to justice, from where I sit as a practitioner, is, first of all, I would need to ensure that the Law Society of Kenya itself is amenable to the multi-door approach to justice. Your Honor, you recall that there was a lot of resistance to the what you call the judiciary kiosk at the Huduma centers. There's been quite a lot of resistance also, even to mediation. And I think part of it is that there's been lack of sufficient capacity building among the advocates in order for them to understand that this multi-door approach to justice does not rob them of their work. I think the fear among advocates is that if there is a multi-door approach to justice, then their work will be reduced.
So you get the stakeholder buy-in,
so
that's one.
So I will do stakeholder first of all. Secondly, I will engage the parties themselves that are before me to ensure that they are amenable to the alternative approach to justice. And I think that is all for now.
Okay. What if parties who've attended an AJS session come and say, "You ilikuwa tu wazee, now I have come to the proper court for justice"?
Thank you, Your Honor.
Yes.
I think with respect to the ADR, I would require the parties to first of all distill the issues before them, so that those issues that they have agreed upon, they can sign a mediation agreement on those issues. And then whatever else is still in contention can be referred to the court. And as a judge, I would sit down and do a hearing based on those issues.
Yes.
And,
would you have
bring a solution.
misgivings enforcing an order or a decision from that process? For example, AJS, would you have a problem enforcing such a decision?
I think it depends on how it was done. I would need to understand from the parties that they understood the process, that they volunteered to undergo that process. And then I would also need to get it from the parties that they are comfortable, that they understand the outcome of the process itself.
Okay. Thank you. Thank you, my lady.
Thank you.
Yeah, thank you very much, CJ. Now, Madam, would you tell us what achievements you can describe to us which are directly as a result of your leadership and vision? What achievements can you describe to us which are directly as a result of your leadership and vision?
Thank you, Commissioner. Maybe can I seek a clarification? Is it achievement in terms of legal work alone or everything?
To the public, to the
Thank
general
you.
community.
Thank you, Commissioner. Commissioner, I have, as a result of 32 years continuous practice, I have contributed to justice, to the promotion of access to justice within our environs. I have contributed to the reform process, to the constitutional reform process. I actively took part in civic education and sensitization of the people on the proposed constitution prior to the referendum. I have engaged in peace building, especially after the unfortunate events of 2007, where there was post-election violence in our area. And I engaged myself in peace building, as a result of which I was given an award by the South Rift Development Forum and the interfaith communities. I'm also a leader of the women ministry in my church, a women ministry known as Daughters of Faith. Aside from that, commissioners, I am a chair of the Board of Governors of Kericho High School and Korongo Girls High School. Kericho High School, I have, with my team of board members, we have managed to bring stability to the school that was facing turbulence for the last 2 years. And I have also contributed to the society by taking care of orphans, vulnerable children, paying their school fees. I have also been a pro bono provider on behalf of FIDA and on behalf of the Cradle for as long as I have been in practice. In fact, I would say that I'm the face of FIDA in Kericho, and I feel that I have contributed significantly and achieved a lot in that field.
Thank you.
Thank you, Honorable Chair. Good afternoon, Council, once more.
Good afternoon, Commissioner.
Please tell us reasons why a judge may be removed from office.
Why a judge would be removed from office? A judge would be removed from office because of incapacity, first of all, mental or physical incapacity. A judge would be removed from office for breaching the code of conduct, the judicial code of conduct, and that is for being corrupt or for gross misconduct, among other things.
I'm looking for those among other things.
A judge would
You've given us 2 reasons.
Okay, a judge would be removed from office if he's in conflict of interest. If a judge acts in conflict of interest, for example, if a judge sits in judgment in a matter in which he has an interest or members of his family have an interest, a judge would be removed from office if by their own conduct or temperament they have conducted themselves so much that they have put the repute of the office of the judge into question by constantly harassing litigants and advocates and being unable to deal fairly and soberly with people.
Doesn't that amount to gross misconduct?
Yes, that is part of gross misconduct.
Yeah.
Yes.
So you will look at that. There's bankruptcy, incompetence. Final question from me. Please give us the guiding principles of leadership and integrity.
The guiding principles of leadership and integrity are founded under that's leadership of integrity, under article...
Under chapter 6.
Chapter...
Specifically.
Oh.
The guiding principles of leadership and integrity.
It is human dignity, human rights, social inclusiveness, equity, equality, rule of law, and social justice. I hope I have not repeated that. Okay. There is also the values relating to governance.
Okay, I just wanted the guiding principles. Yes. You look into that as well. Maybe the very final, if you're successful, you'll be in charge of managing the human resource, which is one of the biggest assets in the institution. And among that, we have a group called millennials, the younger generation.
Yes.
Where do you think is their place, the place for millennials in the institution? And now you would go about managing this very different group of people.
The millennials are a unique group of people. One is that they have skills and competencies which a lot of the older generation do not have, especially in IT, and they are very instrumental in the administration of justice. But secondly, they are also restless, and they tend not to stick to rules and to times. So in order to manage them, first I would make sure that I have frequent meetings with them where we explore how to make their work environment better. I would ensure that as much as possible within the confines of the work environment. I give them ability to engage freely and flexibly, so that if there is work that they can handle at night and it is allowed by law, I allow them to handle that work at night, because I'm aware that many of them do not like working during the day for some reason, which I'm yet to understand. But so I would make sure that I accommodate them as much as possible and give them a good working environment. And also, I also affirm them, because they need a lot of affirmation, so that they understand that they are an important cog in the wheels of justice, rather than just appendages thereof.
Thank you. Affirmation, reward and recognition, they really appreciate those.
Yes.
As well as offer mentorship.
Yes, I will offer mentorship. I'm sorry. I'll offer mentorship. Can I also add something?
Yeah.
I'll also make them understand that they can also offer me mentorship in turn, because I believe in reverse mentorship, where we exchange knowledge. The person who knows better gives the person who knows less, regardless of status, regardless of position.
All right. Thank you.
Thank you very much, Madam Bett. I also wish to declare that I know you. You used to appear before me when I was a visiting judge in Kericho.
Thank you, my lady.
And you are a very active member of the bar and the court user committee, that I confirm.
Thank you, my lady.
Yes, I think this brings us to the end of a very engaging session with you, and we thank you and give you an opportunity also to ask us a question or tell us something.
Thank you, my lady. I think at this juncture I would want to say that I appreciate the opportunity you have given me to appear before you, and I hope that our engagement will be fruitful. Thank you so much, my lady. Thank you, commissioners. It's been a pleasure to appear before you.
I wish you well.
Thank you,
we
my
will
lady.
be in touch when we complete the exercise.
Thank you, my
Keep
lady.
up the good work you're doing to empower the community around you.
Thank you, my lady.
Yes.
Thank you, commissioners. Have a good evening. I think it has become an old joke.